I will introduce our speaker for today. Zach Zipfel is a staff attorney for the Confederated Salish and Kootenai tribes, and he focuses on treaty rights, wildlife management, water rights, and other natural resources. Prior to joining the CSKT, he was an attorney at Montana Fish, Wildlife, and Parks, and his work focused on Indian law, wildlife, and fisheries. He graduated from the University of Montana Law School and then clerked for Justice John Warner on the Montana Supreme Court. And in a prior life, he was a park ranger at Grand Canyon and Denali National Parks. So thank you for being here, Zach.
Thank you, Laura, and I'd also like to say thank you to the library. This has been a great series. I've been fortunate enough to attend a number of the different talks over the last year or whatever it's been, and I'm frankly honored to be a part of that. I hope I can live up to the predecessors. And thank you also to the Montana Historical Society. As Laura said, my name is Zach Zipfel, and I am an attorney for the Confederated Salish and Kootenai tribes of the Flathead Reservation. And in that work, I do a number of things, but there is one thing that almost on a daily basis we talk about or comes up in conversation, and that is the tribe's 1855 Hellgate Treaty between the United States and the Salish, the Pend Oreille or Kalispé, and the Kasanka band of the Kootenai tribe. Kootenai is what they're commonly referred to as, but their word for themselves is Kootenai, and they are the Kasanka band of the Kootenai Nation. And I've been giving some version of this talk now for probably at least 8 years. Every time I do it, it changes a little bit depending on the audience, depending on what it is that I've learned most recently. But it is a subject that is near and dear to my heart on a personal level and a professional level. I guess I'm just sort of a nerd in that way. I spend my free time reading about this stuff, and every time I learn something new, I figure out a way to try and incorporate it into this talk. The field of federal Indian law is unlike any other area of law that I'm familiar with, in that unlike most fields of law, federal Indian law, with the possible exception of constitutional law, it requires you to understand the history behind what happened. If you don't understand the history, you are missing so much of these stories. And so that works nicely for me because my undergraduate degree is in American history. But it's so present in the field. It makes me think of the Faulkner quote, the past is not dead, it's not even past. And my hope is that tonight you will see that come through as we go through some of these stories. And you'll see that it's not past, it's with us every single day. And in particular, for those tribes who have treaties with the United States, those treaties are part of who they are to this day, and it is part of what they rely on and how they see themselves. In the end, the negotiations over the treaties were really about promises that the United States made. Promises to the tribes, and frankly, promises to the American people as well. Anytime I'm learning something new, I always like to go back to Charles Wilkinson. I don't know if many of you know who Charles Wilkinson is. He's an icon in the field of Indian law and natural resource law. I was lucky enough to meet him and have lunch with him on an occasion, and he has a way of boiling these stories down to their essence in a way that really helps us to personalize them. And really, it is about promises. It's about relationships. These treaty negotiations were a meeting of cultures. Cultures that didn't see the world in the same way and weren't necessarily after the same thing. The tribes had a relationship to the land that had developed over millennia, since time immemorial. That's actually a legal term, time immemorial. The United States wanted that land, and they were willing to do whatever they needed to get that land. And if we can keep that in mind, those relationships and those promises that were made, that's when we can really begin to understand these stories and this history and this law in a little bit deeper level. When we talk about federal Indian law, and that is the proper term for it, some people say tribal law because they think Indian law is somehow an improper thing to say. Tribal law actually is a field of law as well. It's how the internal governance of tribes and how their own laws and what laws that they apply to their tribal members. But the field of federal Indian law is the overarching law that applies to tribes. And it starts with the Constitution, as most areas of law do in the United States. Notably, though, tribes are only mentioned twice in the Constitution. One has to do with congressional apportionment. It excludes Indians not taxed. And really today, I think in my day-to-day job, doesn't have a lot of bearing on things. But the other place where tribes are mentioned is in the Commerce Clause. And for those of you who are here for the history and not the law, I promise I'll go through this fast, okay? But the Commerce Clause, I want you to take a look at that and tell me, because it is this provision in the Constitution from which much of the entire field of federal Indian law comes, this one reference to tribes. Do you notice anything about how tribes are referred to in this provision? Anything that stands out to you? Raise your hand, shout it out.
Yeah, they're not foreign nations. They're in another space.
They're not foreign nations.
Yeah. So they're not. So you'll have a treaty with somebody that's not a foreign nation.
Yeah, that's an important point. But they're also compared in some ways to foreign nations, are they not? And they are compared to states. What do foreign nations and states have? They have sovereignty. Exactly. And this right here is critical because it forms the basis of federal Indian law in terms of recognizing that tribes have a degree of sovereignty. And that puts them in a unique place in the American legal system. What is sovereignty? One of my favorite US Supreme Court quotes, the right of reservation Indians to make their own laws and be ruled by them. Now, as I said, this puts tribes in a unique position. And it's important to understand what that sovereignty really means. The Constitution did not grant two tribes sovereignty. On the contrary, it recognized that they already had it when Europeans first arrived here in the New World. Europeans arrived in the New World and they were met with cultures, civilizations that had their own rules for how they interacted among themselves. They had their territories that to varying degrees they protected for their own use. They had rules for how they interacted with other tribes. They had ways of punishing their members for their transgressions. That's all self-government. That's all sovereignty. So the Commerce Clause's reference, it doesn't come out of nowhere. It is a recognition by the drafters of the Constitution that tribes had this ability, this inherent quality of sovereignty. And that is the basis of federal Indian law. Now there are a couple of other provisions in the Constitution that also weigh in on this. The Treaty Clause makes no reference to tribes, but it is an important piece of the puzzle. What does the Treaty Clause tell us about tribes and sovereignty? Who here has ever entered a treaty? I'm going to tell you right now, none of you, and nor have I. And it's because we lack a fundamental quality to be able to enter a treaty. What is that? We don't have sovereignty. We can enter contracts, but we can't enter treaties because a treaty is a contract between sovereigns. And the fact that the United States chose to engage tribes diplomatically through the Treaty Clause or through the treaty tells us again, it reiterates that premise. The United States understood tribes to be self-governing. And again, this between the Treaty Clause and the Commerce Clause, sovereignty underlies both, and that right there, those two things, form the overwhelming majority of federal Indian law, right there, those two provisions. There's one more that I want to talk to you about, and then I promise we'll move on to some other stuff. The Supremacy Clause. The Constitution and laws of the United States and all treaties are the supreme law of the land. Why does the Constitution have a Supremacy Clause in it? Anybody have any ideas why they felt the need to put this in there? Yes, Todd. Yeah, that's right. Who knows what the first form of government we had before the Constitution was? The Articles of Confederation, and there is a good reason we don't still live under the Articles of Confederation. They did not create a United States. It was a loose affiliation of states. And in fact, it prohibited the federal government. There was not enough federally vested authority in a federal government to really be able to govern anything. They had trouble even getting congressional Congress people, I guess at the time it was all congressmen, let's be honest, to DC to vote on anything. And they never had a quorum, so they couldn't pass anything. But even if they could, they had such limited powers. It was almost impossible for them to raise taxes to pay the Revolutionary War debt. You had individual states that were going out, doing their own thing, in some cases trying to negotiate treaties with tribes. They were engaging tribes in trade, all sorts of things, and it didn't work as a government. And so, the drafters of the Constitution came together and they said, okay, well, we're going to try and strike a balance here. Because on the one hand, what we've got right now, there's too much authority vested in the states. We can't do anything collectively. On the other hand, we do recognize some value in states being able to have some autonomy. And so they adopted the Supremacy Clause. And what that does is it says, okay, well, states, you can go out and pass your own laws unless they conflict with federal law. And if they conflict with federal law controls. Now, why are we talking about this right now? The reason is tribes and the law that governs them is a body of federal law. And that puts tribes in a unique position vis-a-vis the states because, by and large, tribal members on reservation are not subject to state law. There's a lot of exceptions. I don't want to overstate that. But it puts tribes in a unique position in the American political order. Because if there's a state law that would presume to apply to a tribe or a tribal member on reservation, there's a good chance it's what we call as attorneys, it's preempted by federal law under the Supremacy Clause. And where does this play into the real world? Taxation. It also plays in, for example, in hunting and fishing. How many of you are getting ready to go hunting? Rowan is. Well, here's the thing. Tribal members on reservation don't have to buy state hunting license. Their own tribe, as a sovereign entity, a self-governing entity, can issue them hunting and fishing licenses on reservation. In some cases, and we'll talk about it here in a few minutes, some tribes reserved rights to hunt and fish off reservation. They do so without state regulation. And that's the Supremacy Clause, preempting that state authority over federal law. So that's the legal background. But why were we in a position as a country where we were negotiating treaties with tribes in the first place? Well, take a look at this map. The 1840s and 1850s were a time of incredible change in the West, and an incredible change for Native people in the West. If you look here, you see in a matter of about 5 years, 1845, Texas was annexed. 1846, Oregon country was acquired by a treaty from Britain. 1848, much of the Southwest comes into the United States. I mean, that's what, 30% of the land base in the lower 48 states that all came under U.S. government control in a span of about 3 years.
Span of about what?
3 years.
3 years.
And this is not to say that there weren't non-native people in the West prior to that. Lewis and Clark came through, but Lewis and Clark were kind of late in the game. There were people coming down, Hudson's Bay traders, Northwest Fur Company traders. The British and the Russians were all over the West Coast and had been for decades, if not centuries. But what changed in the 1840s was what had been a trickle became a flood. So many people started moving west on the Oregon Trail, the other trails that spurred off the Oregon Trail, the Santa Fe Trail. And not only that, it wasn't just the number of people, but it was the fact that as a matter of federal policy, the United States government was pushing people west. They wanted them to go west. The Manifest Destiny wasn't just a slogan, it was a national policy. And that was, I don't want to overstate it, but I don't know if we can. That was apocalyptic to the people who had lived here since time immemorial. They saw the buffalo that many tribes relied on heavily. Their movement patterns changed. Other wildlife was decimated. These wagon trains of settlers, their stock was taking all the grass, taking the water, and this was such a profound impact on the tribes. And so, as many of us would do, they resisted it to the degree that they could. But the fact of the matter, it was simply so overwhelming. Oregon Trail, the numbers explode in the 1840s and 1850s. 1847, Brigham Young shows up in the Salt Lake Valley and says, "This is the place." And Church of Latter-day Saints begins sending people to settle that area. And keep in mind, it wasn't just the settlers themselves, it was all the people that came with them, the merchants, the traders, people who were looking to get rich by selling the settlers things. 1848, 1849, California, Gold Rush. 1850, Oregon Land Donation Act opens up the Willamette Valley south of Portland, which was occupied by numerous tribes. And so the United States realized there was conflict and something needed to be done about it because Manifest Destiny, settling the West, was the national policy, and they couldn't let this go unresolved. And so, thinking back to that Charles Wilkinson quote a few minutes ago, the dusty plains where these promises were made. In 1851, Tom Fitzpatrick, the famous fur trader for the American Fur Company, who at that time had become the Indian agent for kind of the Central Plains, and the Superintendent of Indian Affairs, a man by the name of Mitchell, convened a treaty council. That's near Fort Laramie, Wyoming. It was actually about 30 miles east of Fort Laramie because there was better water and better grazing for stock. And they convened a treaty council there. And because I think it's important that we put ourselves in this mental state, I'm going to read from a phenomenal book, if anybody is interested in this, The Heart of Everything That Is, the untold story of Red Cloud, an American legend. Unfortunately, we don't get to talk much about Red Cloud today, or the subsequent treaties that he resulted in. But this is, I think, puts me in the mental space whenever I think about those old dusty plains where promises were made. It was a pageant unlike anything seen before in the West. In the first week of September 1851, the largest gathering of Indians ever assembled descended on the lush grasslands on the outskirts of Fort Laramie in present-day southeastern Wyoming. They arrived from every compass point: Sioux, Arapaho, and Cheyenne from the North Platte and South Platte River corridors, Arikara, Assiniboine, Mandan, and Minnetarese riding southwest from the far reaches of the upper Missouri, Shoshones from deep in the Rockies, escorted down into the flatlands under a white flag of truce held aloft by the mountain man Jim Bridger. And finally, the stately Crows, completing an 800-mile trek from the buckling Yellowstone Bluffs. Altogether, more than 10,000 men, women, and children from more than a dozen sovereign tribes were represented. Allies, vassals, mortal enemies. Clad in their most ornamental buckskins and blankets, riding their finest war horses, ribbons and feathers flying, they had arrived to hear representatives from the Great Father in Washington make the case for peace. Peace not only between the red man and the encroaching whites, but among the Indians themselves. I wanted to start to talk today about the 1851 Fort Laramie Treaty for a couple of reasons. First off, we're going to talk about two treaties, and they are representative of the two typical ways that treaties were made. One is the peace treaty, and that's what the 1851 Fort Laramie Treaty is. It's a peace treaty. Two, which we'll talk about later, is the land cession treaty. But the Fort Laramie Treaty, there were a couple things about it that were important. First off, this is the opening two provisions of the treaty. You see there Thomas Fitzpatrick is representing the United States, and then it lists the tribes that were there present to negotiate. And then Article 1 of the treaty, this is from the United States standpoint at least, the critical language. The tribes were going to get along with each other. Later in the treaty, there's a provision that says the United States will also protect the tribes from encroaching settlers, and a provision that the United States agrees to pay $50,000 to each of the tribes, spread out over a period of time. The other thing that the Fort Laramie Treaty did, though, and this is critical, is it asked every tribe to identify its traditional territory. And this is the paragraph identifying the Crow tribe's traditional territory. They didn't have GIS at the time, so they are making the boundaries based on geographic spots. The funny thing about this is some of these names change over time. When I was still at Fish, Wildlife, and Parks, I spent on and off over about a year and a half trying to figure out where in the hell 25-Yard Creek was. Because there is no 25-Yard Creek along the Yellowstone today on any map. I happened to find one day, Lewis and Clark, the Daily Journal online, it was annotated, and it pointed out that 25-Yard Creek is the Shields River. But again, it's not necessarily clear if you don't have the context for it. But the Fort Laramie Treaty, 1851, sought the tribes identifying their traditional territories. And so this is a map drawn by Father de Smet, who was there at the negotiations. That's his characterization of what those traditional territories were. I'm just going to say, I think that this is a very European concept of territory. Because I don't think there's any tribe out there that was adhering to straight lines. I also don't think most tribes were adhering to rivers as a fixed boundary on the earth. So from the get-go, we are imposing a European concept on this idea of land and territory through the 1851 Fort Laramie Treaty. I'll give you a more modern example. Unfortunately, that uses Wyoming, which I generally, every time I do a presentation, I try not to reference Wyoming if I can, as a Montanan, but this was the best map I could find. But the reason this is critical is the tribes identified what we now refer to sort of as their aboriginal territory. And why is that important? Because in subsequent treaties, the United States asked them to give up their rights in those aboriginal territories in exchange for a dedicated reservation. And that, at least in part in the Northern Plains, started with the 1851 Fort Laramie Treaty. It wasn't a land cession treaty, it was a peace treaty, but it began the process of getting tribes to give up land. Around this same time, 1850, mid-1850s, there was another series of treaties that were negotiated in the Northwest, Washington Territory, by this gentleman, Isaac Stevens. I will just tell you right now, if you see anything, any place with Stevens as its name in Washington, northern Idaho, or western Montana, it's probably named after Isaac Stevens. Stevens Pass in Washington State, named after Isaac Stevens. Stevensville, Montana, named after Isaac Stevens. Isaac Stevens was the head of a Pacific Railroad survey that was surveying a potential railroad route from St. Paul, Minnesota to Puget Sound, Washington. He was also then the territorial governor of Washington. And keep in mind, at that time, western Montana was eastern Washington Territory. And he was also the superintendent of Indian Affairs. And his entire charge was to go out and settle land claims and open the way for settlement. There's a biography about him that's quite excellent called Young Man in a Hurry. And I would submit to you that sums up his entire approach to negotiating treaties. He really didn't care about Indians. He didn't care about negotiating treaties. He just wanted the X's on the treaty, representing the tribal leaders' signatures. Now, Stevens becomes critical in the field of federal Indian law because he negotiated about 10 Stevens treaties. Only 9 of them are what we call Stevens treaties, really, though. And there's a whole body of federal Indian law. I mean, there's 5 decades of litigation over Stevens treaties. Stevens treaties have been to the U.S. Supreme Court more time than I think any other treaty. And so the reason it's important is it gives us a base of, we get to read where the federal courts are on this particular type of treaty and try and extrapolate that to other scenarios. But he negotiated a bunch of treaties in the Puget Sound area, starting in, I think, right around Christmas of 1854. And then he moved out to the Pacific coast on the Olympic Peninsula, where he negotiated treaties with the Makah and the Quinault. He then headed back inland, hit the south end of Puget Sound, then headed east, negotiated treaties with the Yakimas, what we call today the Confederated Tribes of the Umatilla Indian Reservation, which were Walla Walla, Cayuse, and Umatilla, the Nez Perce as well. And then in July of 1855, he shows up in eastern Washington Territory on the Clark Fork River, west of present-day Missoula, to meet with tribal leaders there. This is a place that not most of you, but many of you have been. It's Council Grove State Park today. And there he met with leaders from the Salish, the Kalispé, and the Kootenai nations. Here on the left is Alexander, the Kalispé chief. If you were here for Sally Thompson's talk a couple weeks ago, she talked a lot about Chief Victor. That's Victor, the Salish chief in the middle. And then on the far right is Michelle, the Kootenai chief. And I think it's useful, and the reason I like to read the old minutes of the treaties and treaty negotiations is because it gives us insight into who they were as people. You can look at somebody in a picture and read their biography, but until you actually see how they interact with other people, you don't really get a sense of who they are. And the treaty minutes from these negotiations, which spread out over a period of about 9 days, which I promise you, for a young man in a hurry, Isaac Stevens, that was a lot longer than he wanted to spend on this. He got very frustrated. But the issue was that Victor, the Salish chief, they lived in the Bitterroot Valley, south of Missoula. That was their homeland. They had no intention of leaving. Alexander, Kalispé chief, the Kalispé lived kind of on the south end of Flathead Lake and the lower Clark Fork corridor, kind of where Highway 200 runs today. Michelle, the Kootenai chief, that Kasanka band lived kind of on the north end of Flathead Lake. And they would travel, farther north. They would sometimes go up into Canada. But Michelle and Alexander were sort of fine with where Stevens had proposed the reservation be. That was where the modern-day Flathead Reservation is today, north of Missoula. Victor wanted nothing to do with that. And so over a period of days, there was a back and forth. Will Michelle and Alexander agree to come down to the Bitterroot Valley, or will Victor agree to go up to what they call the Jocko Reservation? Jocko Reserve, or sometimes they'd refer to it as the Mission, because that's where St. Ignatius Mission was, and still is. And so there on the banks of the Clark Fork, over a period of days, they went back and forth. And there's one exchange between Stevens and Victor that's always, I've always been intrigued by. Stevens says he's getting frustrated because this is supposed to be about a day-long event, not a 9-day event with multiple breaks and feasts and so on and so forth. And he says, and I'm going to paraphrase here a little bit, does Victor even want to negotiate a treaty? Why did he not say to Alexander yesterday, come to my place? Is Victor a chief at all? Is he, as one of his people has called him, an old woman, dumb as a dog? If Victor is a chief, let him speak now. And Victor, this is his response, translated maybe through a couple different languages. I thought my people perhaps you would listen. I said, I think this is my country, and all over here is my country. Some of my people want to be above here, meaning I think the reservation to the north. I sit quiet, and before you give my land away. To me, that exchange gives us such interesting insight, especially into Stevens. And you see there a young man in a hurry, a young man who had grand aspirations. I mean, I think it's well known that he was anticipating at some point running for president, probably. But Victor didn't budge. And in the end, a somewhat of a compromise was reached. There was established through the Hellgate Treaty a provisional reservation in the Bitterroot Valley, and then the formal reservation where it is today, with the understanding that the president would eventually make the decision as to where the Salish would reside. Not to spoil it for you, but I think you know how this ends, right? There is no reservation in the Bitterroot Valley. And in fact, in early 1890s, Victor's son, Charlot, he and his family and that band of Salish were some of the last to reside in the Bitterroot Valley. Settlers had just sort of pushed them out of the way, and in 1891 they were escorted, military escort, out of the Bitterroot Valley, through Missoula, and onto the Jocko Reservation. And that walk today is commemorated in Missoula on the Higgins Avenue Bridge, the Bear Tracks Bridge. The past is not dead, it's not even past. It's around us all the time. Now, the Hellgate Treaty was a land cession treaty. And there in Article 1, you have that operative language. The tribes cede, relinquish, and convey to the United States all right, title, and interest in and to the country occupied or claimed by them. Article 2, however, reserves from that Aboriginal land, and we talked about in the earlier map, reserves a particular portion of land, reserves a reservation. That's where the term comes from. It is a reservation of land from their Aboriginal territory for their exclusive use and benefit. Now this next one is where the Stevens Treaties really make their mark. And this language, right here in particular, is the source of decades of litigation. has been interpreted by the U.S. Supreme Court multiple times. The right of taking fish at all usual and accustomed places, and we should add off reservation, because they have the exclusive right of taking fish on all streams on the reservation. If you ever go up to the Flathead Reservation and you fish, the reason you do so is because the tribes entered an agreement with Montana Fish, Wildlife, and Parks that allows non-members to fish on the reservation, because the treaty reserves the exclusive right to the tribes. But off reservation, at all usual and accustomed places, in common with citizens of the territory, fishing, and the privilege of hunting and gathering roots and berries and pasturing their horses and cattle upon open and unclaimed land. So that's what makes a Stevens Treaty a Stevens Treaty, and that's what led to decades of litigation. And ultimately, in one of the most important cases in federal Indian law, they call it today the Bolt decision. U.S. District Court George Bolt, Western District of Washington in 1974 issued a decision saying that the tribes were entitled to 50% because in common with. He used definitions of in common with from dictionaries at the time. In common with the citizens of the territory meant shared equally, and the implication there was not you and I as fishermen, it was commercial fishing for salmon and steelhead in the Pacific Northwest. George Bolt said that language guarantees them 50% of that commercial fishery. Interesting side note about George Bolt, he graduated from the University of Montana, went to the University of Montana Law School, graduated in 1926. That decision was ultimately held up by the U.S. Supreme Court in 1979. So again, the Hellgate Treaty, this is Stevens' map of the tribal territories, winnowed down to a dedicated reservation carved out of that original Aboriginal territory. So just a couple more things I want to touch on because to me I think they sort of wrap this, put a bow on some of this. When we think about treaty rights, I think that there is a sense that among some people, maybe no one here, but I think there is a sense out there generally that the treaties somehow gave tribes something special, special rights. But in fact, that's not how the courts think of it. The courts say the treaty rights are not a grant of rights to the Indians. On the contrary, they're actually a grant of rights from the Indians, a grant of rights in land, and a reservation of whatever rights they didn't grant. And so when you think about that off-reservation fishing language and hunting language in the Hellgate Treaty, they didn't grant that to the United States. They granted the Aboriginal territory, but they reserved for themselves the right to continue to use that land off-reservation as they had since time immemorial. That's not a special right, that's a promise. It's a promise by the United States to the tribes. And when we talk about how to understand these treaties, remember my reference earlier to 25-yard creek. There are some rules that courts have given us in how to interpret treaties. And they did this in part for two reasons. One, basic principle of law, if you are the person drafting a contract and you make it, all the mistakes in that contract are construed against you because you were the one who had the power of the pen. You could decide what was in that contract, and if you made a mistake, you shouldn't benefit from the mistake. Well, the canons of construction for Indian treaties builds off of that idea. And it attempts to account for the fact that the tribes, as sophisticated and wise as they were at an inherent disadvantage in negotiating treaties with the United States. They didn't have lawyers. They didn't speak the language. They very well might not have even understood really what was going on here. I mean, if you talk to some Kootenai elders, they'll tell you the idea of owning land is sort of silly because the land was here before you got here, and the land's going to be here when you're gone. So how can you possibly say you own it? And so the whole idea of what was even taking place, it sometimes is up for question. And in many cases, we know Isaac Stevens. He had a Salish interpreter available to him. He chose not to use the Salish interpreter when he was negotiating the treaties. He chose to communicate in the Chinook jargon. Anybody know what Chinook is? Yes, it's a trade language. Yeah, trade language with about 500, I've heard maybe up to 1,000 different words, and they're a mix of words. Native words, maybe some Russian, maybe some French, maybe some English, and then some words that just are sort of a derivation of all sorts of things. There is no way you can possibly convey the meanings in that treaty in 500 words. There simply aren't. Why did he do it? He did it because he wanted control, because he was a young man in a hurry. He had bigger fish to fry, bigger things to do than waste his time negotiating treaties. And so courts have given us these rules about how to interpret the treaties. But it's the last one that is the one that I tend to draw upon the most. Treaties must be construed as the tribes understood them at the time they were entered. And going back to that idea that the past is never dead, it's not even past, and the importance of understanding what was going on at that time. Because the law asks us to put ourselves in their shoes, to try and understand what those promises were, to try to understand what people were doing on those dry, dusty plains in that moment. And ultimately, the canons of construction, I think, are an attempt by the courts to ensure that, as Justice Hugo Black said, great nations like great men should keep their word. With that, I'll stand for any questions.
If you have questions, please raise your hand and I'll come over with the mic.
Great presentation. You've been all around this question, but I'm wondering if you'd hit it dead on. Why not a purchase? Why a treaty? For example, Russia sells Alaska in 1867.
Right. Well, and so a couple things. So the treaty, I mean, there was money that was exchanged. So there was a price paid per acre by the United States to the tribes in the treaty. That didn't always pan out the way I think the tribes thought it was going to. And in fact, it got so bad that in the 1950s, actually it was probably the late 1940s, Congress created something called the Indian Claims Commission because there were so many tribes that were discovering that they actually had been underpaid, if paid at all, for the land that they ceded by treaty. And so Congress created a special commission to address that underpayment to tribes. And that took place over a period of probably, I'm guessing about 30 years probably, where the United States then attempted to pay through a commission that was subject to almost a judicial process with all sorts of expert witnesses and identified what the proper value was and then paid that out in claims to the tribes. And at that point, the Congressional Act said, this is the end. Once you've gone through the Claims Commission process, you've been fully compensated for your land. Alaska is a very different thing. That was, the way it was acquired was different. There's almost no, there's no what we call today Indian country in Alaska. Indian country is a term in the United States Code. It means something very specific. I think there's maybe one or two treaty tribes in Alaska, and I think they're in the southeast panhandle, but that bulk of Alaska itself, up there, you had the Alaska Native Claims Settlement Act in 1972 that allowed Native groups to form corporations and then own land as a corporate entity. So there aren't reservations for the most part in Alaska. Very different scene. Alaska's different in a lot of ways. That's one of them.
Did the Senate approve all these treaties And if so, did they have some sort of process? Did they approve them all at once or one by one?
That's a good question. So did the Senate approve all of the treaties? Well, first off, there were a number of treaties that were negotiated by the United States with tribes that were never ratified by the Senate. Most of them that still have stood the test of time were ratified by the Senate. And it sort of depended. Sometimes you would have one treaty at a time. Sometimes they would submit a bunch of them. So there was no real formal process. It was sort of up to however the executive branch decided to present it, the sausage-making process of legislation, right? But yeah, they were subject to Senate approval, as the Constitution requires.
Thank you so much. Do you think you could just quickly talk about a couple of the strong examples of how CSKT has exercised their treaty right recently, like that you've worked on, or other big projects?
Sure. The question is examples of CSKT, and I'd expand that to other tribes, exercising off-reservation treaty rights. CSKT has participated in the Yellowstone bison hunt since about 2007. They were one of the first two tribes, I think with Nez Perce being the other. So as bison move out of Yellowstone, down into lower elevations, leave the park boundaries, trying to find grass late in the winter, early spring. The United States and the state of Montana as well have participated and facilitated a treaty hunt of those bison. CSKT has been a significant participant in that. I think it's around 8 tribes that take part in that. CSKT, basically focuses on bison down there. They can hunt other species on the reservation. There is a fair amount of moose hunting off reservation that the tribes participate in. But to bring this full circle, in 2019, the Crow tribes off-reservation treaty rights were before the U.S. Supreme Court in a case called Herrera v. Wyoming. A Crow tribal member had left the reservation, crossed into Wyoming, and shot a couple bull elk. And he was prosecuted, and as a defense, he raised the 1868 Fort Laramie Treaty, which we didn't get to talk about tonight, with the Crow tribe, which reserves to the tribe the right to hunt on unoccupied lands of the United States. Wyoming said, they had some convoluted arguments, but the gist of it was that the tribe's right to hunt off-reservation had been extinguished, and the U.S. Supreme Court said, no, it hasn't. And so as recently as 2019, the U.S. Supreme Court has heard these arguments and found for the tribe claiming the rights. And then, more broadly, in Washington and Idaho, the Stevens Treaty stuff is really built around salmon fishing and steelhead fishing. And that, you drive to Portland along Interstate 84 through the gorge, you'll see tribal people fishing and selling fish from the road. And that's because of the Stevens Treaty rights.
Given the advantages that tribes have with the interpretation of treaties, what do you subscribe the reluctance of tribes in the last 20 years to pursue more vigorously their treaty rights at the Supreme Court?
That's a great question. Why have tribes been reluctant to pursue treaty rights more aggressively through litigation? I'll just say it that way. Well, the reality is, and this is something we talk about in my work regularly, the reality is that any shot to a treaty is a shot to every treaty. And when you go into court, you risk losing. And the reality is that none of us want to undermine that treaty. And to be frank, the Supreme Court doesn't always we have that 2019 case, and we've had some other ones recently that were not bad decisions. But you're rolling the dice, I'll put it that way, because you don't know what you're going to get sometimes. And so I think for some tribes, the approach has been to work more collaboratively with the state to see if you can come to a common understanding rather than just rush to a courtroom and risk losing something that really is important. Not just legally important, but culturally important to their identity. So I think as a general rule, most attorneys would say, if you can solve something with discussions rather than litigation, that saves you money, and it's better in the long run. So.
I can't resist. My prior life, I was chief of the Indian Resources Section for the U.S. Department of Justice.
There you go.
I argued several cases at the U.S. Supreme Court. I'm not a bleeding heart, but I could feel the antagonism. And the decisions sometimes were based on, I don't know how to say it, but an anti-Indian result.
I'm glad you said that.
I know it. I gave you the opportunity.
I know, and I wasn't going to take it.
I knew you weren't.
Zach, you mentioned before, early on, just even the idea of land ownership must have seemed just absurd, to the Native Americans. As a cultural kind of a core principle, does that still present challenges today?
That's an interesting question, Anthony. The question is whether the tribe's conception of land ownership still is problematic. That's my word, not yours today. And I as a non-native person, I hesitate to speak too much specifically about that. I mean, but the reality is that the tribes are landowners as well, and they're land managers of their reservation. And so I think they, to whatever degree, they've reconciled that in some way. I mean, at CSKT, we have a lands department that oversees tribal leases on reservation land and attempts to acquire. CSK, the Flathead Reservation is a heavily allotted reservation, a lot of non-Indian land within the external boundaries. The tribes are always trying to acquire more of that land and put it back into trust. So yeah, I mean, the reality is we live in the 21st century, and there is a legal regime that we operate by collectively as Americans, and the tribes are a part of that.
So you just mentioned allotment, and I know from reading the 1855 treaty, it's kind of referred to in this really sneaky way of just like the Poncas, and I'm wondering, was that really sneaky? I mean, was that intentionally like a Trojan horse, or is there some other explanation? I don't know if you could talk about that a little bit.
This is a good question. So allotment, just really generally, if you don't know what allotment is, in 1890 or 1887, I think, Congress passed the Dawes Act, the General Allotment Act, which said, oh, by the way, you gave us all that Aboriginal territory, and you got your reservation for your exclusive use and occupancy. Well, we actually don't think you're using all of that, and we'd like some of that too. And so through a series of acts, the United States allotted land within the external boundaries of the reservations. And what that means is they allowed tribal members to make a selection of land, usually around 160 acres, for farming purposes. And when all the tribal members had made their selections, all the land that they hadn't selected was open up to non-Indian settlement. And what Mark is referring to is that in the Hellgate Treaty, there is a provision in there that seems to allude to allotment. I think it's the Omahas, referencing allotment with another tribe. I think Nebraska. Now, interestingly, so we talked about the Indian Claims Commission, where tribes came back and sought compensation for underpayment of that Aboriginal territory. There was also a process that CSKT took part in through the U.S. Court of Claims, which was for underpayment and treaty violations and Fifth Amendment takings for allotment. Now, in that case, that Court of Claims decision, that issue comes up because that was an argument that was made that, hey, when they signed the Hellgate Treaty, they knew this was going to be allotted. They shouldn't be complaining now. And the Court of Claims specifically refuted that. They said that's not what that means. That's not what they thought. And I think if you go back to the canons of construction, that makes sense. Like the idea that they understood what the United States may or may not have done with some tribe they'd never heard of in a part of the country they'd never been to, I don't think it holds water. But as a legal matter, the Court of Claims refuted that interpretation of the Hellgate Treaty.
So this might or might not be related. So you often hear reference to Indian lands, being stolen lands. This was built on stolen land or whatever. And I understand the emotion or whatever behind that. If you're indigenous, obviously you feel like the land was stolen. But how do you respond to that legally? I mean, is there something I'm not aware of? Given what we have with treaties and that sort of thing, was there stolen land from a legal standpoint?
Well, so I think that's, good question. I think that's why, I think Congress felt that there was, which is why they created the Indian Claims Commission, to compensate them properly for the undercompensation through the treaties. Likewise, U.S. Court of Claims, I know the CSKT claim for allotment, which was a Fifth Amendment taking, the Court of Claims determined. I assume, I haven't looked at other tribes, what legal challenges they brought relative to allotment. I don't think CSKT was the only one, though. So to your point, I think Congress and courts have agreed the land was wrongfully taken. Now, I guess we can debate whether that's now been addressed, and it's okay, and we should all just move on with our lives. I guess to me, go back to the quote we started with. Great nations should keep their word, and I'm not sure that the United States has always kept its word when it comes to Native people.
Is that specifically to reservation land that you're?
Well, I think it's to both. The fact that you have these expansive Aboriginal territories, and then they say, hey, you know what? Give all that up. We'll just give you this little parcel here. And then they come back later and go, you know what? We don't think you're using that either, so we want some of that too. I think that speaks for itself. Like I said, whether you think it's been properly addressed, I think that's debatable. But I think there's a long history of not fair dealing by the United States toward tribes.
If I may. The U.S., when I was there, we did bring a trespass action against on behalf of the Iroquois nations for a trespass. And the damages were just like you would claim if somebody trespassed on your land, and we won $500 million.
Yeah, and we're just sitting here talking about a couple of examples. Land cession through treaty, allotment, but if we had the rest of the night, we could come up with a lot more.
So when those treaties were first made, way back when, what was the Indian understanding of money?
That's a good question. And I would say, again, as a non-native, I would hesitate to speculate too much on that, but I do think it's fair to say that they were and had been involved in trading for generations, not only among them.
Trade, but maybe not with currency, not with coin.
Yeah, and I think it's well documented that for some tribes, horses were almost something akin to currency. Somebody demonstrated their wealth and their power by having lots of horses. But the reality is there weren't a lot of places in the West in the 1840s and 1850s where you could go spend a gold or silver coin.
So they would not have a good idea whether the amount of money they were given would be even vaguely
Yeah,
fair.
yeah, I think that's a fair point. Yeah.
With regard to the boundaries of the reservations today, can those be changed? I guess my example would be if a developer wanted to make Browning the next Jackson Hole, Wyoming, and offered to buy that. I mean, couldn't that happen, or is that a fixed boundary?
So there's a series of cases by Chief Justice John Marshall called the Marshall Trilogy that came out in the 1820s and 1830s. The first one of which was a case called Johnson v. McIntosh. And the issue there was, I believe it was in Georgia, and a Georgia resident had bought land from a native person. I forget the details of it. It ends up in the Supreme Court. And John Marshall said, tribes do not own legal title to the land. They have a right of occupancy. And so as a general principle, today, reservation land is held in trust. So legal title is in the United States, and the tribes are the beneficiary of that trust relationship. Trust land cannot be sold. Now, tribes can also own land just like any of us do in fee, and some tribes, I think most tribes do, and they have the ability to treat that like private land that any of us could sell or trade. Now, as far as reservation boundaries being changed, Congress, we talk about sovereignty, it's not absolute sovereignty. Just like the state of Montana's sovereignty isn't absolute. And Congress has what's called plenary authority over tribes, which means if Congress so decides, they can abrogate treaties, which means terminate, get rid of the treaty, no longer honor its promises. They can, in the 1950s, they did. They terminated federal relations with a number of tribes. So all federal obligations set forth in treaties were ended. The tribe was disbanded as a governing entity. The reservation was sold off. And so, yeah, you can do that. It takes an act of Congress. And generally, Congress has not been moving in that direction over the last few decades, and hopefully that will continue. But I hope that answers your question.
Yes, absolutely.
Okay, and we're gonna make this the last question. Sorry, guys.
I'll stick around if people want to ask.
His question just made me curious. So when a tribe buys back or is donated land, like maybe your ancestor got an allotment and so you donate it back to the tribe, does that go into trust, or is that then owned by the tribe, as you were just discussing?
So good question, and it depends, because it depends on what the tribe wants to do with it. There is a process for turning land from fee land back into trust. The last I heard, the process has not been moving quickly. And so that might weigh in on a tribe's decision. But the reality is if it's fee-owned land, there are fewer strings attached. There are fewer protections, but there are also fewer strings attached to it. So there might be circumstances in which a tribe would choose to keep it in fee and do something different with it. So it's up to the tribe. But yeah, there is a process to get it back into trust.
Awesome. Thank you so much, Zach.
You bet.